Introduction to International Law. The United Nations. Peacekeeping and related activities. Peacekeeping and related activities. In the years since the conclusion of the Cold War, there has been considerable United Nations activity in this area. However, it is important to be clear on terminology. In his document, An Agenda for Peace, the Secretary-General, Dr. Boutros Ghali, attempted to set out some working definitions. First, he drew attention to the role of preventive diplomacy, which might involve fact-finding and good offices. Secondly, he identified peacemaking, which might be action taken under Chapter 6 of the Charter. Thirdly, he defined peacekeeping as the deployment of United Nations personnel in an area with the consent of the parties. In contrast, he went on to identify peace enforcement, which involves peacekeeping undertaken without the consent of the parties and is normally authorized under the terms the provisions of Chapter 7. It has to be recognized that the basic distinction between peacekeeping, with consent, and enforcement action has become less clear with the emergence of forms of mixed keeping which may involve elements of each. Secondly, the deployment of forces may be undertaken on a limited basis, but circumstances may dictate a modification of the mandate once the force has arrived in theater. It is clear that the modern law on peacekeeping is a product of gradual evolution. The early actions of the United Nations were designed to supervise truces, as was the case in the Balkans in 1947 or after the Middle East War in 1948. At the same time, it was clear that little progress was likely to be made on making forces available under Art. 43 of the Charter. Secondly, while there is no express provision in the Charter dealing with peacekeeping, there are a number of provisions that can be prayed in aid to legitimize the conduct of the Security Council, the General Assembly or the Secretary-General in this area. So the two relevant questions are: what form of activity is an issue, and what is the legal authority for the activity? However, given the complexities of civil war situations, it has sometimes been difficult to prevent a blurring of these questions. The evolution of the law is best considered historically. In the early years of the United Nations, it was clear that the provisions of Art. 43 were unlikely to be implemented, and it was also evident that, in many cases, the Security Council would be paralyzed by the use of the veto. In these circumstances, the General Assembly sought to fill the vacuum. The first such peacekeeping force was set up during the Suez Crisis of 1956, when the Security Council was unable to act because of the involvement of two of its permanent members. The response of the General Assembly was to set up the United Nations Emergency Force in the Middle East, UNEF, in November 1956 to supervise the ceasefire. The force that was answerable to the General Assembly and the Secretary-General remained in the area until 1967. This initial precedent was followed in the more complicated Congo crisis of June 1960, where the Security Council authorized the Secretary-General Hammarskjöld to establish a peacekeeping force. Pursuant to this direction, the United Nations Force in the Congo, ONUC, was established and took its instructions from the Secretary-General. Because of division in the Security Council, as the situation in the Congo deteriorated, the force was drawn into heavy military operations more akin to enforcement than peacekeeping. The establishment of peacekeeping forces in both the Middle East and the Congo was not without legal difficulty. The forces had been financed separately and not out of the general budget. Some states objected to contributing on the grounds that the forces had not been lawfully established under the Charter. In these circumstances, the General Assembly sought an advisory opinion from the International Court of Justice as to whether there was an obligation to contribute arising under Art. 17(2). In the expenses case, the International Court of Justice held that the expenses of the forces fell within Art. 17(2). In respect of the suggestion that the establishment of UNEF was unlawful, the court noted the power of the General Assembly to act under Art. 11 or Art. 14, while, in respect of ONUC, it was observed that Art. 98 permitted a wide delegation of powers to the Secretary-General. In the Cyprus crisis of 1964, the force sent by the Security Council, UNFICYP, was subject to a detailed mandate as to how it was to conduct itself in dealing with the tension between the Greek and Turkish communities. However, the actual resolution is not specific as to whether the force was set up under Chapter 6 or Chapter 7. Although the wording of Chapter 6 may have had to be stretched, it is strongly arguable if the General Assembly is authorized to act under Arts 11 and 14, then it seems logical that the Security Council should have the same implied power under Chapter 6. In the years 1945–85, it is possible to identify at least 10 forces that generally came within the ambit of United Nations peacekeeping. Generally, such forces were only to act in self-defense, and the usual objective was to ensure the observance of a ceasefire line. Thus, in the Middle East, a second United Nations Emergency Force, UNEF-2, policed the ceasefire between Egypt and Israel after the Yom Kippur War in November 1973, while in 1974 a Disengagement Observer Force, UNDOF, performed the same function between Syria and Israel. A more difficult task faced the United Nations Interim Force in southern Lebanon, UNIFIL, which was sent in 1978 to restore the authority of the Lebanese government in a situation verging on civil war. If there are any lessons from the first 40 years, they are probably that such forces operate best if they are sent with the approval of the entire international community, that they have limited and clearly defined tasks accepted by the various parties in the theater, and they have adequate resources to discharge those tasks. When the objectives are unclear, or the consent of the parties is lacking, or resources are inadequate, then difficulties can easily arise. The conclusion of the Cold War resulted in the decline of the use of the veto in the Security Council and perhaps an undue degree of optimism as to what might be achieved by international peacekeeping. A problem immediately arose because of a blurring of a distinction between peacemaking and peace enforcement, and difficulties developed when forces were sent with fluctuating objectives into internal civil wars. After 1989, a considerable number of peacekeeping operations have been sanctioned, but it is a matter of record that such interventions, even though resolved upon for the highest humanitarian reasons, have had a very mixed track record and resulted in tension between the United Nations and certain important member states. Interventions in Yugoslavia, Somalia, Haiti, and Rwanda may have been dictated by the noblest objectives, but difficulties have arisen when member states are reluctant to send large numbers of forces to undertake open-ended commitments. Both Dr. Boutros Ghali and Kofi Annan have drawn attention to the problems caused when member states pass resolutions for humanitarian or peacekeeping action, but then are reluctant to provide the resources to effectively undertake those tasks. In the years since 1989, there has been an increasing emphasis on the protection of human rights through the establishment of democratic government. To this end, the United Nations has provided technical help in monitoring elections designed to usher in democratic government. However, the experience since 1989 has given cause for concern. First, there is a rather confused line between peace enforcement and peacekeeping. Secondly, some states are increasingly reluctant to commit forces to open-ended commitments. Thirdly, there has been a developing call for the establishment of a special United Nations Rapid Reaction Force, but it does seem that most states prefer to leave their options open and to contribute on a case-by-case basis. In some states, there will be constitutional difficulties in pledging forces in advance to unknown objectives. Fourthly, at the back of such concerns lies the realization that substantial United Nations action over a long period of time requires the active participation of the United States. Those who argue for an independent United Nations force see this as a solution to the problem of overdependence on a single state. Consideration of the state of United Nations peacekeeping since 1989 indicates that the process has moved considerably from its Cold War origins. The distinction between peacekeeping and peace enforcement has become very blurred and is now often hard to determine. The United Nations has moved from policing ceasefire lines in Cyprus and Kashmir to the very hazardous task of intervening in civil wars. Such a move has taken place with only limited debate. There is no doubt that, since 1989, many resolutions have been passed and the number of personnel is over 35,000, but the cost is proving difficult to meet. Some states are reluctant to meet their budgetary contributions and others are unwilling to supply armed forces. While the desire to intervene is fueled by an understandable and quite proper concern to protect human rights, the problem is that democratically elected governments with small professional armies are reluctant to expose their own soldiers to risk in faraway lands in obscure and complex quarrels that have no resonance with their own domestic electorate. Secondly, many such problems are now passed to the United Nations when earlier diplomatic efforts have failed and attitudes are entrenched. Thirdly, the most serious difficulties have arisen for the United Nations when its forces are not operating with the consent of all parties. They can then be placed in the embarrassing position of not being able to help with humanitarian work or being insufficiently resourced to restrain serious abuses of human rights. It is a matter of record that hostile action was taken against United Nations peacekeepers in Yugoslavia, Somalia, and Rwanda, although the problem has been less acute in Sierra Leone and East Timor. The evidence indicates that many states are unlikely to favor open-ended intervention and instead will insist on limited objectives to be conducted in a defined time scale and with the consent of the parties in the theater. In most Western states, the executive branch of government will be answerable to its legislature for the deployment of its armed forces. As the experience of Yugoslavia in 1994 and Kosovo in 1999 has indicated, if forcible measures are needed, then the initial preference will be for the use of air power. The future of peacekeeping was reviewed for the United Nations by Lakhdar Brahimi in 1999, and a panel of experts and their conclusions were discussed at the United Nations Millennium Summit held in New York in September 2000. It was generally accepted that structural reform was needed, with some member states being asked to supply troops and others being required to make a more equitable contribution. However, before these practicalities are addressed, there has to be some agreement as to whether intervention by the United Nations should be on a case-by-case basis or should be by reference to agreed criteria. In looking at the broader picture, it is difficult not to conclude that United Nations peacekeeping has been the unintended victim of post-Cold War euphoria coming into contact with the development of the human rights movement. While the latter trend is certainly desirable, it is arguable that there has been an unwillingness to face up to the practical problems of sending limited United Nations forces into situations of unresolved conflict. In the 1990s, the United Nations has been defeated by warlords in Somalia, and embarrassed over safe areas in Yugoslavia, while being humiliated over events in Rwanda. The two relevant questions are, in what circumstances should the United Nations intervene, and how should any such intervention be managed? There are some who argue that the United Nations should intervene whenever there is a serious risk of abuse of human rights. If that is to be the case, the United Nations will need considerably greater resources.